Welcome, everyone. Welcome to today's TABC Talks edition. I'll be your presenter, and my name is Josh Alexander. I'm the Austin Regional Audit Supervisor, and today we'll be going over new laws impacting retailers as a result of the 86 legislation. Before we get into the presentation, I'd like to go over a few housekeeping details. This agency guidance was developed to improve internal and external communications and ensure more consistent application of TABC statutes and rules. It reflects appropriate processes, requirements, and interpretations based on the general situations presented and may not necessarily apply to every situation. So if you have questions about how this guidance applies to your specific circumstances, please contact the TABC directly. Also, during the presentation, you may interact by using the chat feature located in the toolbar at the bottom of the presentation window. However, I'll reserve answering any questions until the end of the presentation. But if you experience any technical issues, please visit Zoom's Help Center at the attached link. The three bills we'll be discussing today are as follows. Senate Bill 1232, which deals with malt beverage and wine deliveries performed by wine and beer retailers. House Bill 2016, which goes over certain on-premise sales and the increase in the alcohol percentage. And lastly, House Bill 1545, which addresses the package store licensing modifications and the number of package stores that one entity is allowed to hold. Wine and beer retailers may now obtain a local cartage permit and thereby deliver ale and wine directly to consumers with that transport permit. However, holders of the brewpub license that are held with the wine and beer retailer's permit are prohibited from delivering malt beverage products that they produce on the premise for these off-premise consumption. So in other words, if a wine and beer retailer's permit doesn't hold a brewpub license, then obviously they're allowed to make deliveries of products off-premise for consumption. And if a wine and beer retailer's permit holds a brewpub license, they may only distribute those products for off-premise consumption that are not produced on a premise. And these deliveries under Senate Bill 1232 are limited to consumers that reside in areas that are wet for the sale and consumption of beer and wine. Essentially, what the bill does is allow wine and beer retailers to utilize a local cartage permit and have the same privileges as a package store or wine-only package store with regard to making deliveries to and collections from customers. The delivery of ale and wine is limited to the normal sales hours of the wine and beer retailer. And any person making deliveries under this bill must be 21 years of age or older. And also, those delivery drivers must validate that a person accepting the delivery is at least 21 years of age. A valid identification would include a Texas driver's license or any other government-issued form of identification. Also, deliveries and collections may only be made to non-retail locations within the wet areas, but also within the designated county that the wine and beer retailer is located in, or up to 2 miles beyond the city limit in which the retail location is located if that city crosses a county line. Application for a local cartage permit is available on the TABC public website under the licensing section, or you may contact your local TABC office for additional information and instructions. Also note that the local cartage permit carries the same expiration date as the original wine and beer retailer's permit. Beer may be sold and delivered to a consumer without the local cartage permit, as the code does not require a permit for delivery of beer. However, in order to deliver ale and wine, the code requires that you have some sort of transport permit. And therefore, consumer deliveries by a wine and beer retailer without the local cartage permit may result in an administrative case against the primary wine and beer permit. House Bill 2016 affects wine and beer retailers and mixed beverage permits with regard to the alcohol percentage that can be sold on the premise. So currently, wine and beer retailers can sell up to 24% ABV, except, port and sherry wines up to the 24% alcohol by volume can only be sold to consumers for on-premise consumption. This House Bill 2016 expands this exception to additional types of wine, which include dessert flavored wines and rice wines. And these dessert wines are classified under TB regulations as having alcohol content in excess of 14% alcohol by volume, but less than or not in excess of 24%. The final bill, House Bill 1545, increases the maximum number of package store permits that can be issued to a person or the same business entity. Currently, the maximum amount, or prior to House Bill 1545, the maximum amount was 5. And House Bill 1545 increases that number from 5 to 250 permits, and basically eliminates the consolidation of package stores under the first degree of consanguinity, which was previously under Section 2205. What that section did prior was allow the industry to expand a number of the maximum limit of 5 by allowing an immediate family member to obtain a permit in their name and subsequently consolidate that permit with the other family member, resulting in an excess of 5 permits basically. So House Bill 1545 restricts TABC from issuing more than 15 original package store permits in 1 year. Also, an original package store permit can be obtained through acquisition or purchase or otherwise, and may not count against the annual 15 new permits if the existing package store has been in operation in the same county for more than 1 year and the permit holder does not transfer that permit to another county. Again, application and instructions for obtaining a package store permit are available on the TABC public website under the licensing section. And we always encourage you, if you have questions about filing an application, to contact your local offices to speak with the licensing division in your area. In summary, a wine and beer retailer or BG permit can now obtain a local cartage transport permit authorizing them to deliver wine and ale to a customer's home located in the same county as the store, and dessert flavored wine and rice wines up to 24% alcohol by volume may now be sold by wine and beer retailers permit to consumers for on-premise consumption. And as far as the package stores, they're now allowed to hold up to 250 package store permits, but they can only purchase new or obtain new permits up to 15 in one calendar year, or they can acquire existing permits without having to count against that 15 new permit limit. And consolidation of permits by immediate family members and the whole first degree of consanguinity has been removed from the code as a result of the updated or recent legislation. So I know it's been a short presentation, but if you have questions about any of the three bills, now's the time. You can actually ask those questions, and I'll be covering those questions here shortly. But before I get to that, you can also send emails after the presentation to the email here, stakeholder@tabc.texas.gov. And obviously, we'd like to hear from you on any recommendations for improvement on this presentation or any future presentation and or desired topics that you all may have. So the first question is, a BG with an E able to contract with a C as package stores? So with regard to the BGs, because of the fact that the legislation was written in a way to make it similar as far as the transport of the alcohol, with similar to the wine only package stores and the package stores, there'd be no prohibition against the BGs contracting with a carrier's permit for that delivery. However, the important thing to note is they would still have to have that local cartage permit in order to do it. And as a follow-up, are the local cartage permits being expedited like FBs by licensing? Unfortunately, I'm not exactly sure if licensing will be expediting those permits. It may be a follow-up question for our licensing folks. So I can't speak to whether or not those will be expedited, but we can definitely follow up with you on that, once I could get an answer about that. We had heard to make a delivery that food had to also be part of the delivery. Is that true? What you're speaking to is a different part of the legislation which dealt with consumer delivery permits. We did not cover that particular legislation. So the answer to that is, with regard to having a local cartage permit and these type of deliveries, it doesn't have anything to do with the food part. So there's no requirement to have to deliver food with this alcohol under this particular bill. Okay, beer and ale being the same, how is beer able to continue delivery without a license or permit? So what I imagine is going to happen here, and we understand that as part of the recent legislation, beer and ale will be consolidated into malt beverages. That's going to be down the road, and is not effective until 2021. So at that time, there will probably be, possibly some other guidance out there in terms of how we enforce that. Currently, yes, there's no license or permit that's required for beer delivery, but until that law goes into effect, you will be required to hold the local cartage permit for transport with the ale and malt liquors, which are defined as liquor. And currently, the law still states that you have to have a permit to deliver liquor or transport liquor. Okay, and looks like there's food is required to be delivered if a mixed beverage permittee is delivering alcohol per Senate Bill 1450. Once again, the bill that we discussed today had to do with the wine and beer retailers specifically having to being able to obtain a local cartage permit. So that's completely separate from the mixed beverage, which we didn't cover today. And that mixed beverage was granted the authority to deliver utilizing a consumer delivery permit. And under that part of the bill, it does require that those mixed beverages have to deliver food in conjunction with the alcohol. But again, that wasn't addressed today. Today's presentation dealt with the wine and beer retailers and their ability to now obtain a local cartage permit for delivery, which is consistent and similar to what the package stores and the wine-only package stores are authorized to do and have been authorized to do for some time. So they were just given the authority to deliver alcohol similar to those other permits. And again, is separate from your comment about the mixed beverage permittee, which may be addressed in a future TABC talks with the whole consumer delivery permit. So again, I thank everyone for their time today. If there's any other questions, feel free to follow up with us, and you guys enjoy your day.